Hello, welcome to our fifth workshop on Professional Discipline Digest. And this is the first in our current series of 4 workshops that we'll be presenting. And we hope that you can join us for the other 3. So today we're going to be covering freedom of expression. And as before, this is just a little guide to the law behind the professional discipline and regulation that needs to be applied by panels when having to consider an argument put forward by a claimant on freedom of expression. So today your speakers will be myself, Abigail Trencher. I'm a partner here in the employment team, and I also head up our professional regulation and discipline practice here at Burkitt. And I'm joined by my colleague, Eleanor Bullenbell, a solicitor in our employment team, but is also part of our professional discipline and regulation practice. So what we will cover today is we'll take you through the Human Rights Act and pertinent articles to explain where this aspect of freedom of expression comes from and the law behind it. And we'll then be taking you through 3 key case law decisions that will help explain how the arguments of freedom of expression and the consideration professional conduct panels need to give to such arguments. And hopefully that will help to flesh out the law behind this area. And then we'll just conclude on some practical considerations. So to begin with, I'm going to hand over to Eleanor, who's going to take you through the Human Rights Act and the pertinent articles.
Thank you, Abby. So as Abby said, firstly, we're going to look at a summary of the Human Rights Act and its relevance to you as TRA panelists. So, as some of you may already know, the Human Rights Act gives effect to key rights and freedoms under the European Convention of Human Rights. So those are rights that everyone in the UK is entitled to, for example, the right to marry, the right to life, freedom of expression, today's webinar, a fair trial, and so on. And under Section 6 of the Human Rights Act, it is actually unlawful for public authorities to act in a way which would be considered incompatible with one of those convention rights. And the TRA would fall within the definition of public authority. So therefore, it's important that panelists are aware of these key rights and freedoms, because it means that an individual could bring proceedings against a public authority relying on one of those convention rights if that public authority, like the TRA, acted in a way or proposed to act in a way that would be incompatible with one of those convention rights, and they would be a victim of that act. So we'll turn then to look at 2 key articles and their defences. So the focus of today's webinar is Article 10, which is the right to freedom of expression. And then Article 8, which sometimes we'll touch on briefly as there's some overlap, is the right to respect for private and family life. Both of these rights are qualified rights as opposed to absolute rights. Absolute rights are rights that can never be limited or infringed in any way, not even in a declared state of emergency, for example, whereas qualified rights may be restricted or subject to various infringements provided conditions are satisfied. The conditions that need to be satisfied for such interferences or breaches are: it needs to be prescribed by or in accordance with law, necessary in a democratic society, and it must be in the interests of a particular legitimate aim. And underneath the but section on the slide there, you can see the different legitimate aims for the different qualified rights. So just looking at the first condition of that, it must be prescribed by law, so it has to have some sort of legal basis. So in the context of the TRA, if an infringement is alleged and argued, you would therefore look at whether the teachers could reasonably foresee that their actions might conflict with those TRA professional standards. And then, as I said, it needs to be necessary in a democratic society. So it goes no further than is necessary, and it needs to be proportionate in relation to one of those legitimate aims listed on the slide there. So if we turn then to have a little look at Article 10 in a bit more depth. So freedom of expression includes individuals expressing their views aloud through other means like published articles, books, radio, broadcasting, social media, and it's the right to hold and express opinions as well as imparting ideas on others. So it's not necessarily just written words, it can be images, pictures, actions, anything basically to express an idea or present information. As I said, it is a qualified right, so the interference with it can be justified where necessary, for example, in the interest of public safety, to prevent disorder or a crime, the protection of other rights, or the protection of reputation or the rights of others, as I said. And there's a longer list on that previous slide of the different legitimate aims. I will now then just hand you back to Abby to go through the first two of our key cases today.
Thank you, Eleanor. So the first of the cases we're going to look at is the case of Mr. Khan versus the Bar Standards Board 2018. So Mr. Khan was charged with 3 counts of professional misconduct. And this related to a client, information that he'd received from a client of his who had asserted and alleged that she had been subject to a serious sexual assault by another individual. And Mr. Khan made comments relating to those alleged allegations in the robing room of 2 courts. And his comments were overheard by individuals who knew the alleged perpetrator. He also, and this is of interest to Article 8, he also contacted the wife of the alleged perpetrator on LinkedIn. And those were the 3 counts of professional misconduct. So it was all to do primarily in respect of expression of freedom of interest, to the comments he made in the robing room, but also there was this other ground that referred to the contact he made with the alleged perpetrator's wife on LinkedIn. Mr. Khan pleaded guilty to 3 charges raised against him by the Bar Standards Board, and was given a sanction of 7 months suspension for each of the 3 counts, but which would be run concurrently. So it was 7 months in total, effectively. Mr. Khan appealed, with 2 of the grounds being that he had a complete defence to the charges under the Human Rights Act, which he hadn't put forward at the panel hearing, because of the advice he'd received at the time. There was in the judgment and in the appeal a lot of discussion about whether he was able to adduce new evidence and new grounds, but the view was taken that he could. And he argued that he was not advised by the council before the Bar Council standards panel hearing of the impact of the Human Rights Act on his case, and particularly the right, obviously, freedom of expression, and that he considered that should have been engaged in this case because the comments he made in the robing room were protected because they were his freedom of expression to have such conversations. Mr. Khan expressed that there had been no assessment of the impact that the case might have on his freedom of expression in those comments in the robing room, which he said would have had far-reaching effects because the robing room is a private room for counsel to spend before and after a court hearing. They will often exchange private confidential information with each other in the robing room, and that therefore that should not afford that should be taken into account in respect of comments that he made in the robing room, on whether it's fair to determine that those amounted to misconduct, given the interference it would have on his freedom of expression. And Mr. Khan stated that had he been advised, he would have pleaded that he was not guilty, and been able to defend himself of those charges. So, just getting, sorry. So it was determined that even if Mr. Khan had been advised of his right to freedom of expression, those defences would have failed. It was recognised that Mr. Khan's comments in the robing room are speech protected by Article 10. So the panel and the court were persuaded that they were valid arguments, and that it was a context that he should have had an aspect to be able to make certain comments, and therefore they did engage his Article 10 rights, which cover speech which is no more than abuse. However, the court, in looking at the comments that were made, how they were made, determined that the justification and the qualification that applies to freedom of speech should also be engaged in this instance. And it was stated that a central function of the Bar Standards Board was, in being a regulatory regime for counsel, is the protection of the reputation and rights of others. And it was further noted that in this case, the disciplinary measures served the function of preventing the disclosure of information received in confidence. And the interference had pursued legitimate aims prescribed by law and had been a proportionate measure corresponding to the pressing social need to uphold and maintain standards in a profession of critical importance to the public welfare. So in this case, what they looked at is Mr. Khan's right of the freedom of expression, but they also looked at the alleged perpetrator, whose name was bandied around quite openly and was overheard in the robing rooms, and consideration was given to the fact that Mr. Khan did not take care as to how he had his discussion. He didn't make sure that it couldn't be overheard by others in the robing room, and it clearly could be overheard, and neither was he careful with the information that he imparted. So whilst there was a lot of discussion about the fact that he made it clear that this was information he'd received from a client, nonetheless, it was deemed that he should have been more careful in how he had that discussion and been aware of the damage that the information he was imparting could have on the reputation of others, namely the alleged perpetrator, particularly because they were alleged offences and no criminal proceedings ever followed. So it was recognised that he was very careless with the information that he imparted and in the environment in which he imparted it, and it could therefore damage the reputation of another person. And it was recognised that therefore that should be qualified, that should qualify his freedom of expression, that notwithstanding he has the right in that environment to talk about matters, he had to still observe his professional duties of confidence and to recognise that to be careful about the reputation of others. And Mr. Khan's appeal was dismissed as a result. And in respect to the LinkedIn, he also tried to argue that that was an article that was a freedom of privacy, because that was a private conversation he'd had, and he got short shrift by the court for that defence too, on the basis that was also a qualified right, and he should have also considered the right to privacy of the individual who he contacted, who was not aware of any of these instances that he was referring to, albeit very opaquely. So his comments on LinkedIn were very nuanced and were not expressed assertively, but it clearly was nonetheless an intrusion into that individual's right to private life, and therefore that qualification also came in respect to the qualification on his right of privacy in respect to the fact that he hadn't safeguarded that of another's. So his appeal was dismissed. So now moving on to our second of our three cases, Martin Diggins versus Bar Standards Board. So yes, another case involving council and the bar. So in this case, Diggins was an unregistered barrister, which means he didn't hold a practicing certificate at the time. And it concerned an open letter that was put out on Twitter, posted by a young black female student at Cambridge University, where she posted the open letter to the English faculty, which stated that the result of a meeting that took place amongst students about the need for the faculty to decolonise its reading lists and incorporate post-colonial thought alongside its existing curriculum. A call to not be so arrogant so as to assume civilization began with the writing of white men, and so this should be the basis of our learning. McDiggins was upset by that open letter and responded in a tweet using language that was found to be both racist and sexist, and was explicit in ways that could be deemed to be offensive. Mr. Diggins' tweet contained a URL, a link to his personal website, and that personal website identified him quite clearly as being a barrister. Mr. McDiggins did not delete the tweet, and neither has he, and did he apologise for it. The day after the tweet was made, the Middle Temple referred him to the BSB, a complaint that Mr. McDiggins had used their Twitter account linked to their personal website to post a racist and sexually explicit slur against a young black Cambridge student. So it was the fact that he'd posted this tweet that was both racist and sexually explicitly offensive and a slur, but also that in doing so he had identified, or he had made a link that could render himself identified as a barrister. A professional conduct panel hearing took place, and they upheld the charge, and a fine of £1,000 was imposed. So McDiggins put forward 5 points of appeal at the hearing, one regarding misdirection of area of law, which included, did the panel's approach ignore or err in its approach to his human rights? And did the panel err in relation to Article 10? McDiggins' barrister before the appeal court, argued that the panel failed to recognise that McDiggins' participation in the Twitter spat was an aspect of their private life, which, as a matter of human rights law, Article 10, falls wholly outside, Article 8, falls wholly outside the proper scope of professional regulation, with the consequence that the prosecution represented an unlawful interference with his human rights under Article 8 of the Convention. And the panel failed to acknowledge, properly or at all, that his free speech rights at common law and under Article 10 were protected. So in conclusion, it was determined by the appeal court that McDigan's tweet was protected under Article 10. It recognised that he has a freedom of expression that should be protected. However, referring to the case of Khan, it was determined that the interference was justified under Article 10. The court recognised that the tweet was offensive, it was racist and sexist, and it also recognised that by putting in the link that he had, he could be recognised and acknowledged as a barrister. It was therefore upheld reliance upon Khan that was conduct that potentially damaged the reputation of barristers and the public confidence in the profession. And in terms of the sanction, the imposition of sanction represented an interference with Mr. McDigan's convention rights under Article 8. McDigan's right to say that the conduct in posting was an aspect of the personal life. However, it was determined that interference was also justified under Article 8, that there must be a limit on what you can post and how you can post in one's private life, particularly if you do it on Twitter, which is a public forum. And also his response on tweet was to the Cambridge University and their student unions post. So it was a direct tweet back to a University of Cambridge tweet. So in that respect, it was also qualified and the justification was upheld. So that concluded McDigan's appeal on his sanction. So I'm now going to hand you back to Eleanor, who will take you through to our third case.
Thank you, Abby. So one final key professional conduct case to be aware of is the case of Mohammed Adil v General Medical Council. So just to look at the facts, Mr. Adil was a local surgeon, and during the pandemic, he appeared in several videos that were published on YouTube, where he presented himself as a doctor and spoke about the pandemic being a conspiracy. So by way of examples, he said such things as, and I'll quote directly, so open quote here, the COVID-19 pandemic did not exist and is a conspiracy brought by the United Kingdom, Israel and America. The COVID-19 pandemic is a multi-billion scam, which was being manipulated for the benefit of Bill Gates, pharmaceutical companies and the World Health Organization, close quote, or words to that effect. So Mr. Adil didn't dispute the fact that he was in those videos and he said those things, and the Professional Conduct Tribunal found each allegation proven. And following that, he was suspended from his registration as a doctor for a period of 6 months. Mr. Adil then subsequently appealed this misconduct decision to the High Court, arguing that the tribunal's decision was inconsistent with his right to freedom of expression under Article 10. So there was, among other grounds, the first kind of two main grounds that we'll look at today were that he argued that the interference was not prescribed by law, which is one of those conditions to qualify the right, as the guidance fell short of the requirement of foreseeability. So he was saying that he couldn't foresee that it was prescribed by law. And then the second ground was that he argued that in any event, it was a disproportionate interference with his right to freedom of expression. So just turning to the next slide then, we'll look at his grounds of appeal in a little bit more detail. So the General Medical Council guidance, it was held that even though it was framed in general terms, it was clear that it applied to his social media use, and the guidance also made clear that serious or persistent failure that presents a risk to public trust in doctors can amount to misconduct. So looking at that, the court concluded that the only sensible way to understand that statement was that that would put your registration as a doctor at risk if something did amount to misconduct. The court then went on to explain that even though it was a general obligation, it was sufficient for that prescribed by law purposes, and it was capable of being basically readily understood by members of that profession that it's something that you shouldn't be doing. And therefore it was held to be reasonably foreseeable that Mr. Adil's actions might conflict with his professional conduct standards. And then turning to the second ground that Mr. Adil was looking at whether the interference with his freedom of expression was a disproportionate one. So as I said, there was no dispute that Mr. Adil's comments were made and that it was in exercise of his freedom of expression, nor was there any dispute that the tribunal's decision that amounted to misconduct was an interference with that freedom of expression right. However, when they looked at it, the court in particular referenced the panel's findings, and I'll quote here again. So open quote, "It was far beyond helpful, legitimate comment and went into the realms of scaremongering conspiracy theories," close quote. And the court held that that was an honest description of the matter. So when looking at it in more detail, they were trying to maintain good standing of the medical profession, which was in pursuit of one of those legitimate objectives under Article 10 that I went through at the start, namely the maintenance of public trust and confidence in the profession. Mr. Adil then went on to further argue that it did breach his rights because he was actually acting outside of his medical profession. So he was doing it in his spare time, taking part in these YouTube videos, and he wasn't doing it as part of his time as a doctor. The judge disagreed with that comment, making clear that it was the fact that Mr. Adil was presenting himself as a doctor that was significant in their findings. And they noted that it was clear that the substance of Mr. Adil's remarks squarely engaged his professional responsibilities. So he was holding himself out to be a doctor in those YouTube videos, even though it was conducted outside of work. That did not mitigate the fact that those comments were made and was held to be misconduct. And it was particularly significant to the judge that he was using his position as a doctor to promote something which obviously at the time was an opinion of particular medical importance. So the outcome of Mr. Adil's appeal was therefore that it was not a disproportionate interference, and his appeal was dismissed, particularly considering the potential damage that it could have had on the medical profession. And they said that it was likely to diminish and undermine public trust in the medical profession. So it was right that to qualify his right of freedom of expression and be restricted in the way it was necessary for the interests of public safety, the protection of health, and the rights of others, and so on. That concludes the key cases for today. So I'll now pass you back to Abby to finish the session with some practical considerations.
Thank you. So in conclusion, I'll just forward the slide. So where does that leave us? So it is likely that from time to time, panels will need to consider whether articles under the Human Rights Act are in play, either because that's put forward as a defence by a teacher, or other registrant, or otherwise put forward and advised to the panel by the legal advisor or legal assessor, as the case may be. But of itself, that isn't the end of the story. The first step you need to take is to decide whether the article has been triggered, and in the case of freedom of expression, whether there has been an expression that is before the panel that does engage Article 10 of the Human Rights Act, which protects expression so far as it is not abuse. And if that is the case, the panel then need to go on to consider whether or not that interference in the right is justified by looking at one of the conditions. And we set out here the conditions that are set out in the Human Rights Act. And the one that is likely to come into play more often than not will be the one that is highlighted and put in bold there, which is that it's qualified, it's a necessary interference for the protection of the reputation and rights of others. So the panels will need to consider, is there an expression that is protected? And if so, is the interference with that right necessary? And as we've heard in these three cases, it was deemed that it was, and it was for the protection of the reputation and rights of others. So the most likely context in a TRA hearing is going to be the need to protect the reputation of other teachers and to protect the public's confidence in the teaching profession. So they're the two steps that you should be taken to by your legal advisor and your assessor. And I hope that our webinar today has helped to explain the background to that legal advice that you're likely to be taken to should such a defence and such issues be in play in a case that you're hearing. So that concludes our section today. As mentioned, we do have another 3 sessions in this current series. So I hope you'll stay in touch with us. We'd love to hear how you found the session. And also if you've got any comments about other topics that we can cover in these series, and if not in the current series, we'll try to do that in future ones. So please let us have your comments. Please let us know what else you might like us to cover, and we'd love to see you again at our future webinars. So thank you very much from Eleanor and I. Thank you.